So, thank you so much. Good morning, everyone. And as I say, thank you for joining us for today's webinar, where we're going to be discussing the new Workers' Protection Act and what it means for employers. My name's Gemma, and I'm CEO and co-founder of Culture Shift. Just to give you a little bit of background about us, if you've not come across us before, we exist to transform organisational cultures so that people belong and feel safe to speak up if they don't. A core way that we deliver this is through our safe and simple piece of software that empowers people to report culture damaging behaviour directly to their organisation. You can hear more about that later if you choose to stay on after this webinar, where we'll be giving a 15-minute demo at the end of this call. I'm delighted today to be joined by Caroline Prosser, who is a partner at Hill Dickinson. She's put a lot of time into designing this session for you so that by the end of it, by the end of this hour, you'll know everything you need to know about the Act itself and how it's going to impact your organisation and what you can do to prepare for that impact ahead of the legislation coming in October. So, Caroline, over to you.
Hey, hi everybody. So I'm going to talk to you today about this new duty that's come into force. So it's a new duty to prevent sexual harassment, and it's contained in the new Worker Protection Act of 2023. So the whole point about it is the burden is shifting. It's no longer solely on the individual to challenge inappropriate conduct, but on the employer to prevent and tackle it in the first place. So I'm going to look at what the duty is and how to discharge it in further detail during this training. So it comes into force in October 2024, but there are steps you need to start taking now to prepare so that you're compliant in October when it comes in, because you have to be compliant in October. So you have to be ready. Just so you know as well, for the purposes of this Act, an employee has a much wider definition than your traditional employee definition. So it does cover job applicants, it does cover workers, employee shareholders, and wider, including self-employed, as long as they're carrying out the work personally. So if you could go to the next slide, please. So this is what I'm going to cover in this section. I'm going to go through these in this order. So I'm going to look first, if you go to the next slide, at what is sexual harassment. Okay, so sexual harassment itself is defined in the Equality Act, and that is where A engages in unwanted conduct of a sexual nature and the conduct has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for B. So we need to consider each element in turn. I've got on the next slide, I've got a non-exhaustive example list of what sexual conduct of a sexual nature is, so I'll go through that in a moment. The Equality and Human Rights Commission, the AHRC guidance, advises that the word unwanted means the same essentially as unwelcome or uninvited. And it does not mean that express objection has to be made to the conduct before it's deemed to be unwanted. Okay, so it also describes unwanted conduct of any nature, including verbal, non-verbal, physical conduct of a sexual nature. And we'll talk about how that also implies online and at work events, etc. It doesn't matter if the unwanted conduct is not intended to cause the distress, that's important, as long as the conduct has the effect of violating a person's dignity or creating an offensive environment. In fact, whether the unwanted conduct violates a person's dignity or creates an offensive environment depends on the victim's perspective and whether their reaction is reasonable in all of the circumstances. And I'm going to go through some case examples just to give you an idea about how that's perceived in practice. So if you go to the next slide, please. On this slide, I have put out some examples of what sexual harassment could look like. This is a non-exhaustive list. I've just picked out some things, such as flirting, gesturing, making sexual remarks about someone's body, clothing or appearance, asking questions about someone's sex life, telling sexually offensive jokes, making sexual comments or jokes about someone's sexual orientation or gender reassignment, displaying or sharing pornographic or sexual images or other sexual content, or touching someone against their will, which includes hugging. So if you could go to the next slide, please. So Sexual harassment can happen to anybody, can be carried out by anybody, to anyone, and a one-off incident alone is enough to be harassment. It can be an ongoing pattern of behaviour, but it can just be the one incident. We've got to bear in mind, as I said before, it could occur in person. It could occur by other means, such as social media, WhatsApp groups, messaging, inside and outside work. So we'll look at that later, work events. And it includes treating someone less favourably because they've submitted to or refused to submit to such behaviour in the past. So I'm just going to give you some bit of context around that. So first of all, just to clarify, just to be sure that a single event is enough to constitute the harassment. Secondly, there is no need for B to have made it clear to A that their conduct is unwanted for it to constitute harassment. This was a case, in situ cleaning company case in 1995, where the employer argued that a man could not know whether his conduct was unwanted until it had been rejected. And that argument failed because the EAT said, of course, that would be giving would-be harassers. They can't be allowed to test the water to see with impunity whether or not their conduct was objectionable to potential victims. So they can't just do what they need to do and wait to see if it's rejected. So the EAT's view was, if the conduct is serious enough to be reasonably considered as harassment, there does not have to be a rejection of it or an objection to it. Sexual conduct that's been welcomed in the past can become unwanted in the future. So an employee could actually succeed in a claim for sexual harassment where a consensual relationship ends and the other party's conduct then becomes unwanted. And this actually happens quite a lot in practice. I see this quite a lot in practice, where a relationship's ended and then there's some behaviours afterwards. And there's a case, the Chief Constable of West Midlands Police, which was in 2014, and the EAT upheld the tribunal's decision that an employee had been sexually harassed for 2 days after an 18-month relationship with her work colleague had ended. So it didn't matter there was 18 months of consensual relationship. When it had ended, there was 2 days worth of harassment after. Also, the fact that an employee is put up with the conduct for years, it does not mean that it cannot be unwanted. Nor does the fact that the employee initiated banter as a coping strategy means that it is not unwanted. I'm going to give you a case example here. This was a case called Smith and Renrod. Miss Smith was employed as a sales executive in a car dealership, and she claimed that she'd been sexually harassed by her manager. She alleged that his behaviour included telling her that he had not heard what she was saying because he was, quote, thinking about picking you up and F you on the desk, attempting to kiss her, pestering her about her private life and making speculative comments about her sex life and relationship with her boyfriend, and who also worked at the dealership. Now, in that case, it's really interesting because the tribunal did find that there was a culture of sexual banter in that workplace, and in which Miss Smith and her manager both actively participated in. However, whilst it concluded that Miss Smith was not shocked by the day-to-day banter between colleagues and that the day-to-day banter in itself didn't go too far, the tribunal did find that the comments made by her manager did go too far, and that the type of personal innuendo and questioning that he engaged in was offensive to her and it was unwanted conduct. So whilst the tribunal, because we look at the impact on the victim, whilst the tribunal found that Miss Smith herself was relatively robust and not adverse to participating in or even initiating the sexual banter, they found that the conduct and comments of a manager went beyond what was acceptable to her. And I mean, in this, my advice and always is to not allow a culture of this kind of banter, because this is where problems arise. But just so you know that just because there is banter, it doesn't mean to say that it can't become unwanted later. The tribunal in this case also took into account the fact that it would be harder for Miss Smith to have dealt with and complained about the behaviour of her manager, because it's always going to be harder for an employee to complain about a manager naturally than any other colleague. And it also noticed where there's a culture of sexual banter that exists particularly in a male-dominated industry, and it's actively condoned by a male manager, a female employee may feel compelled to join in with and not obviously take offence at the language and conduct that they would actually otherwise find demeaning. So that was really a helpful case. So if you could go to the next slide, please. So I'm going to look at what the new duty is. What does it look like? The new duty says you must take reasonable steps to prevent sexual harassment of employees in the course of their employment. So how does this work? So just to start with, you probably know this already, but the Equality Act already prohibits both sexual harassment and less favourable treatment because an employee has rejected or submitted to conduct of a sexual nature. So sexual harassment is already prevented by the Act. And also is already the case that employers can be vicariously liable for sexual harassment carried out by their employees in the course of their employment. However, if they get a claim, the employer may have a defence if they can show that they took all reasonable steps to prevent the harassing employee from acting unlawfully. A report by the HRC concluded that actually this wasn't sufficient. Whilst there was a defence, when people brought a claim, they felt that this wasn't sufficient to protect workers from sexual harassment actually being made in the first place. So they made these recommendations, and this is where this new law change came in. So where does this new law take us? So we've already got a law against sexual harassment and a defence. But now this new law that's coming in October requires you as employers to take reasonable steps to prevent the sexual harassment of employees during the course of their employment. So it sits alongside the existing duty, that's the defence. So you're not allowed, so there can't be sexual harassment in the workplace. It doesn't create a standalone claim that employees can bring an employment tribunal, the new preventative duty. But what will happen is, if there's been a breach of the duty, if there's any sexual harassment claims that go to tribunal, then this new act allows the employment tribunals to increase any compensation awarded at the tribunal by up to 25% if the employer has not actively engaged in this new preventative duty. The 2023 Act also gives the HRC powers to enforce the new duties as well. So I'm not sure if anyone's come across Section 23 agreements, but Section 23 agreements have been made between the HRC and various employers in relation to where there's been allegations of harassment. It's that the HRC have powers to carry out investigations. They have powers to enter into these Section 23 agreements, which are public agreements. So the Highways Act were in one and Sainsbury's were in one. And they can also, the HRC can assist with certain disputes. So whilst you have it's for the employee to bring a tribunal claim that brings this duty into force when you're looking at the sort of awards that can be awarded, there is also this ability for the HRC to intervene as well. So you really must make sure that you are complying with these duties. The Act originally did include some provisions about third parties. And what happened was there was provisions about protecting your employees against third parties, but during the parliamentary process and when it was in the reading at the House of Lords, they actually took this part out. So now there's no proactive obligation to prevent harassment by third parties under the new law, even though that's what was originally planned for. That's gone. However, you cannot simply ignore this issue. Under the current law, an employer still risks being liable for discrimination or harassment itself if it ignores complaints about harassment from a third party and it continues to put vulnerable employees at risk. And irrespective of legal risks, it is simply not good practice, and it's reputationally damaging to fail to prevent staff from being harassed at work, even if it's not by your own employees, it's by third parties. So it is the HRC made this really clear as well in their guidance. They said there's no explicit legal duty to prevent third party harassment. It may at some point still come in, you know, it's not maybe not gone forever, but however, the guidance is really emphatic in saying that, you know, you have to deal with this third party harassment under the legal provisions that exist already. So for example, indirect sexual discrimination could be claimed if there's a policy of failing to deal with such issues, particularly disadvantages women. It could be, you could get direct discrimination claims if you fail to deal with complaints by certain groups of people. So particularly women here, when we talk about the sexual harassment, if it's by a third party, it could come under direct discrimination if you don't treat it properly, to the way you'd normally treat a grievance. Also, if you don't treat complaints properly, even if they're by third parties, if your employee brings a grievance or complains and you don't deal with that properly, they could end up resigning and claiming unfair constructive dismissal. So regardless of the fact that at third parties is not specifically set out as a legal duty in this act, the other areas of the Equality Act that are already in there cover the protections that you need to look after for your employees, so you must take it seriously. So let's look at sort of how this proactive duty sort of works with the current legal obligation. So as I said, the law already provides a defence to harassment if the employer can show they'd taken all reasonable steps to prevent it from happening. This meant it was advisable to take such steps, but there was no actual requirement to do so. So the new law goes a bit further by placing a separate legal obligation on all employers to take the proactive measures to prevent sexual harassment. So I'm going to look at what that looks like in practice now. So if you could go to the next slide, please. So what is this? What are they asking us to do for the preventative steps? So unfortunately, there is no guidance at the moment on this in the new law. The AHRC are currently in the process of updating their guidance. Their other guidance was from 2020. They're looking at updating their new guidance now. I believe from looking at the commentary that's probably going to come out in around June. This will be guidance only. A statutory code of practice has been promised several times, which would be law, but it may not. I very much doubt it's going to be ready by October 2024, because we would know, because it would be in consultation stage at the moment. So what it's actually asking you to do is to ensure you are prepared for the new duty in October, even though it's unclear what might constitute the reasonable steps that you're supposed to be taking. So what I'm going to do is sort of look at that, what we believe those reasonable steps look like, even though there's no guidance or statutory code. I'm able to look at what the current legislation is and sort of reflect that to tell you what I think the preventative duty is going to require. So the Employer's Defence in the Equality Act, you might have noticed my emphasis on the word all. So the defence in sexual harassment claims is the employer took all reasonable steps to prevent the discrimination or harassment. And the word all was removed from the new duty in the parliamentary process. Means that it looks like a lower threshold because it's about taking reasonable steps. But nevertheless, we believe that the employment tribunals are probably going to interpret it in a similar way to the existing employer's defence. So if you want to go on to the next slide, please. So let's look at the reasonable steps defence. So what I'm going to do is look at what the reasonable steps defence is to the claims, and then that could be we can use that to interpret what we need to do for the preventative duty. So the reasonable steps defence that exists at the moment is that you took all reasonable steps to prevent the harassment. So an employer is not liable for harassment committed by a worker in the course of his or her employment if it can show it took all reasonable steps to prevent it. So the AHRC guidance actually emphasises that the steps must be taken before the harassment happened, although how an employer responds to a complaint helps to show the issue is taken seriously. And I'm going to look at how we respond to complaints in a bit later in this. The guidance says that an employment tribunal may expect an employer to take certain steps, even if it would not have prevented the harassment in the particular case. And it also says that even if a step's likely to be effective in preventing harassment, it might be reasonable, even if it's expensive, time-consuming or troublesome, using the example of training all managers on anti-harassment policies, for example. So we'll go to the next slide, please. So I'm going to look at prevention. So I'm going to talk practically now about how we believe this is going to look and the steps that you need to take. It's looking at some very sort of what we know, that what we believe is going to be considered, but also actually what you actually need to do, and steps you need to start taking now. So I'm going to start with staff engagement. You've got to know what's going on with your staff to start with. You conduct regular one-to-one meetings, run staff surveys and exit interviews, use information to understand issues and effectiveness of solutions. Managing regular contact with staff is the best way to understand the issues and effectiveness of any steps taken. And staff feedback should be given serious consideration and factor into important ongoing review and improvement of preventative measures. One of the things that's really important is about knowing what your actual culture and your risk is at the moment. I know employers say, well, we don't really have any issues, but how would you know if you have issues, if you don't have a sort of forum where employees can tell you about it, or you don't have a way of reporting? Because what's really going to the next point is you've absolutely got to have a reporting system. You've got to have something whereby you can create and update central reporting registers for complaints about all forms of harassment. You've got to consider setting up reporting systems which allow anonymous reports to be made, and such systems could capture complaints that would otherwise then go unreported. It can encourage complainants to come forward, and it can allow some form of action even if a full investigation is not possible. So I'm going to talk about dealing with anonymous and a bit later, but I want to bring Gemma in here because one of the things that they absolutely say is you've got to have some kind of complaints database. So as well as you've got to have a database and a facility for people to be able to make these complaints, and it's got to be GDPR compliant, but it's got to be in a level of detail so you can analyze trends. So I'm just going to bring Gemma in here because she's going to talk about what that can look like.
Yeah, obviously this is something that is obviously like core to what we do at Culture Shift, and it's something that within the higher education sector in the UK, they are now very au fait with the concept of having a centralized reporting system that allows for people to make anonymous reports about unacceptable behaviour. It's something that the corporate world, shall we say, is lagging behind a bit. I think that, just anecdotally, there's a certain level of discomfort with allowing for anonymous reports to be collected. But it's really important that you do, so that you can be showing that you're giving people a forum to raise these things. Sexual harassment is insidious in its nature. And if people are brave enough to come forward and say that the behaviour is taking place, that's a pretty rare thing. And so in order for you to be proving that you are taking all of those reasonable steps, you have to give people the facility to be able to raise it in some way. And often that means giving them the sort of ability to be anonymous, even if that's initial, so that you can know about the information, because knowing about the problem means that you can be taking a proactive approach to tackling it. But just kind of turning a blind eye and said, well, no one told us, isn't good enough now. You also need to be able to analyze trends. And I think there is actually a question in the chat about like what can you do if people are anonymous, and so we'll probably come to that later. But the trend analysis, understanding if there's a certain issue around sexual harassment within a team or within a department or within a geographical location, having that information gives you the power to be able to tackle it. And that goes back to the certain things that Caroline was talking about earlier, whether that is particular types of training, informal conversations, formal conversations, to be able to kind of go down the disciplinary route. The knowledge is the power, and that is the shift in perspective, I would say, that this act is compelling organisations to do. Would you agree, Caroline? Oh, you're muted. That's all right.
Yeah, absolutely. I mean, the key thing is can you hear me? Sorry.
Yeah.
The key thing is that it's not enough now for employers to sort of turn a blind eye and say, well, we didn't know there was a problem. We haven't got, and it, you know, if they haven't got a database or a list of a central record of what complaints have gone in, it's a bit like when you look at the disability provisions. Employers can't say, well, I didn't know they were disabled, to get out of their obligation to make reasonable adjustments. It's going to be like that. So sort of turning a blind eye to it and pretending that you don't have a problem and not having this database or not having this method of assessing your risk isn't going to wash anymore. You absolutely have got to know what your risks are. And I'm going to come to sort of looking at a risk assessment in a moment, but I will take the sort of Gemma spoke about anonymous complaints, and there's two things on that. First of all, your anonymous complaints gets you the information, so you can collect the information. But secondly, we don't need to necessarily worry about if they're anonymous to start with, because what we need to do is we need to provide a forum for people to come forward. And as you know, when you're carrying out investigations, you have to be fair in the investigation. So if I was going to carry out an investigation for someone who's accused of sexual harassment, it would only be fair if they knew who it was and what the details were for it to be a full investigation. Now, ideally, therefore, we need it to not be anonymous. So what I've done in practice, though, is I've allowed people can come forward anonymously, and then there's a facility for them to be talked through what that means in practice. And I know Gemma's going to be able to tell you, because they can actually do this as part of Culture Shift. What I did in a particular investigation as it is very similar to sort of what the Culture Shift does, will be doing sort of standardly, is allowed people. I spoke about the process with them, so I told them how it worked, what would be done with their evidence, who would see it, how it would be used, and I allowed them to get to the point where they'd even seen all their minutes before they then confirmed if they were happy to go ahead. So sometimes people aren't going to come forward if they think they're going on record straight away and they're a bit nervous. But if you say to them, look, you can withdraw your evidence at any time, but come to me now, speak to me, I will take down the information, then you can decide if you're happy to go ahead when you've had the process explained to you and they've had a bit of support, because it's quite nerve-wracking being a witness, of course. And in that case, it worked for me. I managed to get, in a case I did recently, there was, I think, 18 witnesses, and only 2 people decided not to go through with giving their evidence. All the rest of them agreed to go with their names on, which made it much, much easier for me, because then I was able to put the names to the person accused. I will, if people refuse to give their names and they stay anonymous, there's still got to be some kind of limited investigation that you do around matters, but it's just not going to be the same as being able to put to somebody for a fair case. But again, another point is that once somebody's made a complaint of discrimination or harassment, it doesn't require them to raise a grievance. So in normal circumstances, I'm sure you've all come across this with your employees. Somebody says, oh, so-and-so has done this, so-and-so has done that. And you say, well, do you want me to do something? Oh, I don't want you to do anything about it. I'm just telling you, and you can't do anything about it. And, sometimes you have to wait for them to raise grievance. It's not the same in discrimination and harassment. If you are put on notice of discrimination and harassment, you have to carry out some kind of investigation. And hopefully it's a proper full one where they give their name and you can do all, but sometimes it isn't. If it's the case that somebody reports something in and it's anonymous, you just do the best with what you've got, which might not make a finding or a case to answer against the alleged perpetrator, but there's got to be an element of looking into it to discuss. So you have to absolutely look into and also, even if somebody says, if you get a complaint from person A about sexual harassment and they say, I don't want to take it any further, as an employee organisation, you still have to investigate, even if person A doesn't want you to. So it might be, again, a limited investigation, because it'd be third party. It'd be just the person it reported to who would then be interviewed. But just so you know, we can make anonymous, hopefully, people to give their evidence when they feel comfortable. And it all goes back to the culture. If the people feel in their organisation there is a culture of dealing with these things properly, they are much more likely to not be anonymous. If they feel that there's a culture of not dealing with things properly, or it won't be dealt with, that's when it's more anonymous. But the more you deal with complaints properly, the more likely people are going to be to put their name to them. So I'm going to look at policies now. So a major thing with the we know what's going to be in terms, as well as obviously recording, assessing everything, you absolute minimum, you've got to have your policies sorted. So you must update and recirculate anti-harassment and speak up policies, and you must ensure that policies focus on inclusion as well as equality. So you can have ideally a separate sexual harassment policy. If not, it can be within your other harassment policies, but you must have these 9 essential elements in a sexual harassment policy. You must have a policy statement, you must have a definition of sexual harassment, a description of to whom, where and when the policy applies, guide of how to report sexual harassment, an outline of responsibility of management and staff, description of the formal grievance and investigation procedure where they can bring their claims, where they can bring the complaints, description of the possible sanctions and how sanctions will be decided, statement of zero tolerance for victimisation and retaliation, and commitment to reviewing and evaluating the policy. Now, with your policies, if you're not sure if your policies are up to this level, obviously I can assist by looking at your policies. We can redraft them for you. We can review what you've got. That's no problem at all. Absolute basic is get your policy right. There's more to it, but if you haven't got your policy right, that's going to be a real difficulty for you because it's the first step. You should also at least consider publishing your policies on your external facing website for easier access, and also just to make a public commitment about eliminating harassment. You also need to make sure that you actually discipline employees for harassing colleagues on social media. So policies need to cover, your sexual harassment needs to cover your social media and any out of work harassment that could call into question their suitability to carry out the role. So you must make sure that all of your policies are linked. So your disciplinary is linked with your social media, linked with your sexual harassment, and they all work together. The other thing that's really, really important is that policy should not overstate sanctions for malicious complaints. So it must be made clear to the worker that they will not be disciplined just because their complaint is not upheld. This is really, really important because people worry about bringing there's often a big statement in the policy saying complaints are going to be malicious complaints will be subject to disciplinary action, and people then feel nervous about bringing a complaint. Now, an employee should only face disciplinary action if it's found both the allegation is false and it was also made in bad faith. So to put that into context, if a person raises a complaint, it's for the investigator to investigate it. Now, the investigator may uphold it or they may not. Just because they don't uphold it does not mean that it's been made in bad faith. And that is really, really important to appreciate that, because I know I've done investigations myself. I carry out investigations. Sometimes I've upheld them and sometimes I haven't. But it doesn't mean the person bringing them is then subject to any disciplinary sanction if I don't uphold it. What people are never, ever prevented from is their own lying. So if somebody's lying about something, then of course, if it's then not upheld and we found that it's been brought in bad faith, then yes, absolutely, they'd be disciplined. But sometimes policies are they're so keen to stress about malicious complaints that actually puts people off raising them, when really, if you've got a good investigator doing this, your investigator will be able to decide if it's upheld or not upheld properly without putting anybody bringing a complaint, either the person bringing the complaint or the person accused, at risk, because it will just be done properly and a proper finding will be made.
I think this is like one of the sort of key issues, really, is that that is malicious complaints is something that employers overstate more than what constitutes sexual harassment and what what will happen as a result of that. So therefore, people prevents people from putting forward a complaint because they're worried that it might not be upheld or believed. And yeah, that's a major problem, particularly I think with sexual harassment, but all kinds of discrimination, that organizations are more clear on malicious complaints and talk about it more than they do about that poor behavior and what will be done with the perpetrator of that poor behavior.
Yeah, absolutely. It is really, really important to make sure that there's a culture where people feel they can bring the complaint. And like I say, we'll talk about how you look at complaints in a moment, but it is for you to train and have people properly able to look at these complaints properly. So in fact, I'll go on to the next slide and we'll look at training. What we've got to have is carry out up to date, tailored and situational training to help staff members avoid the threat of harassment, and to give those who witness harassment, so bystanders, the means to safely intervene or support victims. So employers should train all workers in the different types of harassment and victimisation and ensure that the training is refreshed at regular intervals, including how to address third-party harassment where applicable. So training which is stale or simply a tick box exercise is unlikely to be considered a reasonable step to prevent harassment. And staff also need to know how to raise issues when they occur. So what they're saying here is if you've got some sort of e-learning that you just pop on your on your system and people do it, but it's old, it's been there for a while, there's no sort of test after, it's not been refreshed, that's no longer going to pass this test. You actually have to show that it is updated and it's regular, and it's what that looks like in practice is difficult, because essentially when you're looking at wanting to do something, you're looking at your culture. Those employers that really want to change the culture, and they might train all their staff in live training sessions. Employers that are really large might not have the facilities to be able to do that. They might want to put these as online training, but you might want to have a workbook with it to make sure that they're assessed, to make sure that they've actually, done a little assessment after to show they've understood. That would go towards showing it's properly looked at. There is element of perhaps training managers live and putting the other ones up perhaps online for employees. So there's no set way to do the training. It's just about it won't pass the test now if you've just stuck it on your sort of portal and you're expecting people to do it. Because we actually need also to make sure we train the senior leaders and managers themselves separate to the employees, because they're the ones who need to identify the risk areas and highlight their role in modelling the right behaviours. And it's also crucial steps that employees can take to proactively reduce the risk of issues arising. Also, they actually have to, as well as showing, if you're training the managers, it shows that you're taking all reasonable steps to prevent harassment, because you're training the managers who are actually trying to watch for this behaviour as well. And secondly, the managers have got to actually be trained in how actually to deal with the complaints. So how you deal with the complaints, it goes towards whether or not you're complying with this duty. So sexual harassment is quite a difficult thing to investigate, because it is a legal point. It is a defined point. For example, victimization. People say on being victimized. Victimization is actually a specific legal test, which is about being treated to a detriment because you've done something which was a protected act. So it's about, for example, somebody being treated to a detriment because they were a witness in a sexual harassment claim. So it's very specific. So if you're asking someone to investigate a complaint, that person investigating absolutely has to know what they're investigating. So you need to train your managers on how to investigate properly. Also, you need to bear in mind that it's a very difficult area and it's a very, very sensitive subject. And so your managers that you are asking to do these investigations must be able to answer questions sensitively and properly. I do sexual harassment and sexual misconduct investigation myself. I do independent investigations into lots of areas, fraud, misconduct, all sorts of things. But I do them in relation to sexual assault and harassment because they are very difficult. And sometimes, I've had to do it with very young people. I've done it with students in universities as well as staff. I've done student complaints. And you're asking people very sensitive questions about things, about what happened, and you have to ask them in detail about what actually happened, and it can be quite difficult sometimes for managers to do that. The other thing you have to ask is, for example, I had to ask the question of a particular student, how much had he had to drink? And this wasn't because I was suggesting that she'd welcomed any kind of assault because she'd had a drink. I just had to assess whereabouts the level of consent was. So I needed to know how much she'd had to drink so I could assess whether there'd been consent or not. So it's a very difficult question to ask, and you've got to ask it very sensitively. So, just asking any person in your team to carry out these investigations is rarely going to be sufficient. They need to be well trained and very sympathetic.
I think, sorry to just interject there, Caroline. I think the key thing is being survivor centric. And yeah, you put it in a sort of way there that it's being sensitive, but I think, it's really important that the people conducting these investigations are trained in survivor centric methods. And like you say, it can't just be handled in a standardized way or a kind of an uninformed and unskilled way because of the ongoing repercussions that the poor handling of a complaint could impact a victim survivor going forward. So I can't sort of overstate that enough, really, that it needs to be done in a survivor centric way.
And there's no risk to doing it in that way, because essentially the evidence will play out whether something happened or not. And a good investigator will be able to find on the evidence if something happened or not. So, for example, so when somebody makes a complaint, so I had a complaint of a sexual assault, and you go at it with as if the starting point is you're trying to find out what exactly happened, and at the end of it, I made a finding, and in a lot of cases I make a finding that there was sexual assault. In this particular case, I made a finding that that there wasn't, but there's the way you deal with it because the evidence and the facts, and there was text messages that supported that there was consent given, but I treated the person making the complaint very seriously as a victim. There's no, the facts will play out the actual result. So you don't need to worry about, you need to treat everybody in the process properly. You don't have to worry about sort of, people sort of start with the right, they're innocent till proven guilty, or guilty till proven innocent. It's not. When you're doing a fact find, you're trying to find out what happened. That's the most important part. And to find out what happened means you can be sensitive and careful and understanding with everybody you speak to. In terms of your training materials, if you want, I mean, again, I've written training materials for clients. I have reviewed training materials that they've got. If they want me to do that, I can carry out your training. Some of my clients, I train the HR, and then the HR train their staff. Some of my clients who've done a massive overhaul, they've put actually us in to train the staff, or we've done a podcast, sort of a video for them to use as training. Lots of different types of different types of assistance you can have. Also, as well as in terms of the training, consider appointing guardians or nominated champions in the area. So employers should make sure that there are trained workers who can support a complainant through the process of making a complaint. So they could be members of the HR team or appointed guardians. Because as I say, people need looking after in this process and need to know that their complaint will be taken seriously. The investigator themselves is the one who looks into it to assess all the evidence. As well as training, the next thing is I've got risk assessments. So these identify the risks and the control measures to minimize the risks. So risk factors could be things like power imbalances, job insecurity. I've done a lot of sexual harassment claims where it's been 0 hours workers, or it's been freelancers. Those people in more vulnerable positions are less likely to make complaints. Therefore, if there's a perpetrator, they look for their victims. They may go for people who are less likely to make complaints. People where another risk factor is presence of alcohol, which obviously sometimes in sort of work events means that people's inhibitions are lowered. Customer facing duties with third parties, particular events that raise tensions locally or nationally, lack of diversity in a workforce, if there's a culture of banter or a particularly male dominated area, for example. The other thing to bear in mind is people on secondment. If you've got an employee on secondment, how are you managing the risk? Because you're responsible for those employees on secondment. So how are you managing to make sure that they're safe where they are? And also the impact of remote and hybrid working. Look at this, because the reduction in day-to-day contact with managers and the teams is likely to mean that managers are less attuned to how their reports are and what's happening with their team. So red flags of harassment that you may well have seen are easier to miss because of remote working. And just so you're aware that during COVID, there was a lot of complaints of harassment carried out remotely. So it didn't necessarily, just because people weren't together, it didn't mean to say that harassment went down. It just changed its forum. So you, as an employer, you've got to consider carefully what risks your own workforce faces, because it's going to be different depending on what your setup is. And then you've got to identify what steps you need to take to address them. So when the slides are sent out, there's a risk assessment in there. If you want to fill in the risk assessment and send it back, and you want us to look at it, we can look at it for a one-off fee of £750. We can produce you a RAG report to tell you what your risks are in each of the areas. And then you can either look at it yourself and sort it out yourself, or you can engage us to help you. But if you just want, there's no obligation, obviously. If you just want to fill in the risk assessment and you want us to look at it, we can do. And if you're compliant, great. If you're not, we can always tell you what you need to do. And like I say, you can do it yourself or you can get help. So moving next into the next slide, please. So we're looking at, so basically, whilst the guidance acknowledges that the damage done by harassment, it does offer an important reminder that it is not an inevitability. Is employers can and must take action to change culture and behaviours and eradicate harassment in the workplace. So the watchword here is proactivity, not just about how you deal with the harassment, it's also the steps taken to prevent and avoid it. So make sure you update your sexual harassment policies at minimum, sort your training out, make sure you know what your risks are, make sure you've carried out an assessment so you know what's going on, make sure you're aware of what your risks are. So these are all proactive. And I'm just going to go on to the next slide now, which is about actually dealing with the complaints themselves. So if you're on the next slide, it's like managing complaints. You absolutely have to look at what a clear route is to raise concerns about sexual harassment. You've got to have multiple reporting routes, informal, formal procedures, anonymous reporting, and encouraging to speak up. So you've got to ensure that there's a clear avenue for reporting complaints and that all complaints are investigated, as I said before, and dealt with effectively, even if they're historic as well. A key issue thrown up by the Me Too campaign was that employers should investigate historic issues rather than assuming that they can't find evidence just because they occurred a long time ago. If something's very specific and there's a very particular, say a particular assault, that even if it happened 4 years ago, somebody should remember if they did or didn't do it, to be asked. If it's maybe a banter that happened 8 months ago, they may not remember, but then you don't assume that they don't, you still investigate it. And even if you can't make a finding because it happened too long ago, you can still look at cultures. So don't dismiss things just because they're not raised within 3 months or 6 months or whatever, you must investigate them. So I'm just going to sort of pass to Gemma in terms of the actual reporting and how the culture shift can do this.
Yeah, I think we are really at the informal sort of end of the process, really. It's our belief that early intervention is absolutely key. And so if people can raise issues informally, either anonymously or with their name, so that people can, so that the organisation can know about it and then take a proactive and preventative approach from things escalating, then that's the kind of ground, I guess, that Culture Shift occupy, all the way up to kind of handling full-on HR complaints. The part about anonymous reporting, one of the key features that we are that's in development at the moment is two-way communication with anonymous reporters. The reason for that is so that you can ensure that the person who has chosen to report without their contact details is supported and signposted to all of the right information so that they can be processing and getting the right support for what it is that they've experienced. But it also gives the organisation the opportunity to manage that person's expectations as to what would happen if they were to make a formal complaint. They can talk about what next steps could happen. They can talk through all of the different options that are available to them. And so I think it's really key to managing people's expectations in this process that is undeniably difficult, even in the absolute best of circumstances, is the best thing that you can do for a victim survivor. It's just really paramount that expectations are managed and that people kind of are very clear about all of the steps of the process, so that they're kind of forewarned is forearmed, and they can make an informed choice about how they progress through the kind of complaints process, all the way from informal disclosure all the way up to formal grievance process.
Yeah, so essentially we're saying, and treat all complaints seriously and sensitively, keep the reports confidential, provide ongoing support to the employee who made the report, provide guidance to managers on how to deal with it, use specialist independent investigators if necessary, consider whether you need to put interim protections in place to protect the complainant and the witness. So just be really careful. If somebody raises an allegation, you don't move the person making the allegation out of the team, because that could be seen as a detriment. You would always, if the suspension might be appropriate, if not, you might move the alleged harasser out the team. Now, this is a neutral act because we haven't made a finding yet, but the point is that if you have to move one person, you don't move the person who's made the complaint. If a worker makes a complaint that's maybe a criminal offence, you should speak to the individual about whether they want to report the matter to the police. And if they do want to do that, you support them. Now, just because someone doesn't want to report it to the police doesn't mean to say they don't have a genuine belief in it. As you know, the police have a far different standard. It's beyond all reasonable doubt, whereas the employer standard is a balance of probability. Sometimes people don't feel comfortable going to the police because of there's such a low conviction rate eventually, but they want to bring it to the employer. So they may want to go, if they go to the police, support them. If they don't, you still need to look into it. And finally, just deal with your harasser properly. Don't let staff get away with the acts of discrimination because they are high performers or it's their first offence. The amount of times I used to hear in the past, but he's our best salesperson, and you'd be like, well, you know, you can't really do that. Don't attempt to sweep any allegations of harassment or discrimination under the carpet. Just doing so will just make it worse in the long run. So obviously when you're dealing with the person making the complaint or the victim, when it's found, you must obviously that nobody should ever be treated to a detriment or sacked for bringing a complaint. That's obvious. But also make sure that there are other elements that are not, so they're not treated to any detriment, they're not shunned by people or anything like that. So make sure this is all about your culture as well. It's about culture of people knowing that there's a zero tolerance to sexual harassment, and that sexual harassment is dealt with properly. And if that's the case, generally speaking, then everything will be dealt with properly. And finally, I'm just going to look at third-party facing steps. So even though it's not explicitly covered in the Act, this is the last slide, sorry. We still need to consider our position on third-party facing steps. So harassment by third parties, such as a customer, client, patient or supplier, should be treated just as seriously as that by a colleague, as I said before. So you've got to consider how you can sort of take steps to prevent this type of harassment. So including putting in reporting mechanisms in place or assessing high-risk workplaces where staff might be left alone with customers. You can consider third-party facing steps like installing visible signs in areas where customers interact with staff. Members explaining that threats of violence and harassment will not be tolerated, and also provides a means of support and for bystanders to report instances of staff harassment if they witness it. When considering taking what reasonable steps looks like going forwards for this preventative duty, it's always going to be important that we factor in any guidance that comes in from the AHRC. As I said, this is likely to come in June, we think, maybe, as well as any code of practice that comes in later. We will, if you want to subscribe to our database for Hill Dickinson, we update our clients, we update our contacts, and we will let people know when there are new, when there's any new guidance or any new statutory code coming out. And we always let our clients know, and then we let them know what they need to do in time. So yeah, so that's it. Every last slide. Do we have any questions?
Yeah, we have got quite a few questions actually. I'm really conscious of time, but let's try and get through as many as we can do. So I think yeah, I think you've partially answered this, but I'm gonna ask the full question that this person has submitted. So, what is the ideal approach to follow if a few individuals complain about an individual within a department or area regarding sexual harassment, but do not want to make a report and do not want to go through a formal process?
Okay, so this is something I've dealt with in practice, and what I did was I spoke to the individuals separately, and because you need to speak to them separately and not together, because you need to make sure that what you're taking is their own version. And I sat down with each one separately and I explained to them what the process would be. And I said to them, I encouraged them to tell me what had happened and said, look, tell me what's happened. And there's no obligation for me to use your evidence yet. Okay, you can pull out at any time. there are, as you can say to people, you're not the only person. You cannot tell them who the other witnesses are. You can say you're not the only person. Sometimes people are frightened to come forward because they think that they're the only one. So what I did was I took the evidence from them and I went to each and I did exactly the same process with each, getting the evidence from them, explaining the process. And then I went back to them individually and said, are you prepared to go forward? Are you prepared to go forward? And actually, in that circumstance, each time, the vast majority have decided to go forward with it.
And were you able in that situation to say that there were a number of complainants going forwards? Because often
Yeah,
there's often a situation where people wouldn't go forward just if they're on their own because of the pressure of that. But then
sure.
when there's sort of a group complaint,
Yeah.
it can make it more likely.
Yeah, I mean, obviously you can't tell them who they are because the integrity in the investigation means you don't want the witnesses to speak to each other. The chances are that if there's a group of them, they probably know anyway. But what I always say to people is, you're not the only person making a complaint, and that's as far as you can go. So, or once sometimes people give their evidence, and they give their evidence and they say, oh, it's happened to a third party. So, that they say, well, this has been reported in by a third party. This is about you, so I need to speak to you, but it's been reported in by a third party. So then they know that somebody else has seen it. So
Mhm.
there are elements of being able to do that without compromising the integrity of it.
Yeah. There's a question or a few questions in the chat, so that I think is quite important to get to before the end of this. So can you explain if sexual harassment is gross misconduct or not? Would employers be failing in the new duty to prevent sexual harassment if if it did not dismiss a perpetrator? Is a risk that if the employer doesn't dismiss the perpetrator, they will go on to sexually harass?
Okay, so most of the time, sexual harassment is going to be gross misconduct. It's But sexual harassment is any unwanted touching. So we need to look at everything's got to be looked at on its facts because unwanted touching can include a hug. Now, if somebody hugs somebody, that's not necessarily going to be gross misconduct, but it doesn't mean to say that they wanted that. So sometimes someone hugs somebody, the case is going to be perhaps talking to the person saying, actually, don't hug people unless you know they want it. So not all, we have to look at each thing on its facts. Sexual assault is always going to come down to gross misconduct. Where you have something that is worthy of a dismissal, you also have to consider the mitigating factors as well. So every case is going to turn on its own facts. So it's not a case of something happens and it's automatic dismissal. Every single investigation and every single disciplinary is looked at separately. But where you have a serious case of sexual harassment or assault, a lot of the time it's going to be gross misconduct. But if you are seen to deal with things, it doesn't necessarily mean dealing with things means everybody gets sacked. It's about dealing with things, taking complaints seriously, changing cultures, putting people on sanctions. So it doesn't have to mean if you don't dismiss, you're not taking it seriously.
Yeah, okay. I don't think we've got any time for any more questions now because we're just about at 12 o'clock. I really wanted to answer the question about the fair deal for working people. When it comes to third party harassment, I don't think the book is sort of closed on this. I think that the This Is Not Working campaign will continue to try and campaign on this so that it can be extended to third party harassment. But that's a really interesting question. So and thank you for all of your questions today. Really, really appreciate it. We will be sharing the slides. As Caroline mentioned, we will be sharing the risk assessment. We will also try and answer your questions that you've asked that we've not been managed to get to today. Thank you so much for joining us today, Caroline, and to all of the people that participated today. This, as you would imagine, isn't the last time that we'll be talking about the Workers' Protection Bill. This is kind of the first in a lot of activity that is going to come from Culture Shift to help employers prepare and be ready for when the legislation comes in October. So please look out for future presentations or white papers or research that will be coming from Culture Shift over the next few months. We are going to conduct a quick demo now. So if you want to stay on, I'm going to hand over to Gemma and Paul, who will be able to show you the Culture Shift system. And thank you very much for joining us today.